Good morning. We'll hear argument in 21-1037, Hotze against Turner from Harris County and the 14th Court of Appeals District. Petitioners represented by Andy Taylor and respondents by Colin Petty. So we'll begin with you, Mr. Taylor.
Good morning, Mr. Chief Justice, and may it please the members of the court. For 19 years now, Proposition 2 validated and enforced. I'm getting a message that my internet is unstable. Can you hear me?
We can.
Okay, great. Sorry. So there's really two main issues I want to talk about this morning. First is whether or not a portion of an election ordinance, we call it the poison pill, seeks to destroy the validity and enforcement of Prop 2. The second issue surrounds a local charter provision. It's Article 9, Section 19 of the Houston City Charter. And it says that if two propositions are passed at the same time and they're inconsistent, then the one that has the more votes than the other survives. And so the question there is whether there's inconsistency. Your Honors, about the poison pill, there's really three parts to that. Number one, is the poison pill part of Prop 1? Two, if it is, was it triggered? And triggered, is it enforceable? If the answer to any of those three subparts is no, we win on issue 1. And I'm going to go to that. The poison pill can only be found in one location. That is in the city's election ordinance. It is not something that the voters voted upon. As we all know, at the city level, the city charter, if you will, is the constitution for the city, and ordinances must be subservient to that charter. The only way that you can amend your charter is through a majority vote. That's clear under the Texas Constitution and 9005 of the Local Government Code. So you cannot, just by simply passing an ordinance, cause a proposition that's part of your city charter to go away. It has to be voted on by the voters. And that's what's wrong here, is that the municipal ordinance, the election ordinance that put all of this stuff on the ballot, makes clear that what's going on the ballot is the information within quotations for Props 1 and 2. Nestled in between those two things is this so-called poison pill language. And it doesn't require inconsistency. It just says, hey, if Prop 1 gets more votes than Prop 2, then Prop 2 is invalid. The city doesn't have that authority to do that. We can tell by the documents that were in the summary judgment record that even the city thought Prop 2 had passed. Why do we know that? Let's look at the adoption ordinance. That's the city saying what passed. And the poison pill language isn't in the adoption ordinance, or the canvassing ordinance is a better way to say that. If we look at the actual text of Props 1 and 2, it's not in there. If we look at the newspaper notifications, where twice in the Houston Chronicle, they actually quote all of Prop 1, it's not in there. If you actually get on the current website for the city and look up the city charter, as I did last night, it's not in there. The Prop 1 doesn't have this poison pill language in there. So even the city early on realized that this poison pill language wasn't part of the propositions that were passed. And they also started certifying early on. If you look at the summary judgment record, the city put in evidence before the trial court that the comptroller, that at the time was Anise Parker, who eventually became mayor. Anise Parker, as comptroller, she certified that the budgets in 2006 and 2007 for those fiscal years had complied with Proposition 1 and 2. The city wasn't acting back then as if the poison pill language destroyed Prop 2. And so the first point is that the poison pill language just simply isn't in there. The second point is, let's just assume you disagree, like the Court of Appeals and the trial. Then the question is whether it was triggered. The poison pill language says that it's only triggered if it relates to a limitation on increases in city revenues. So in other words, Prop 2 has to relate to a limitation and increase in city revenue for Props 1, its poison pill language to have been triggered. We argued that that didn't happen. Proposition 2 is very different than Proposition 1. Proposition 1 has three parts. It focuses on property taxes and caps it at a certain level in terms of being able to assess and collect. It also talks about senior citizens being entitled to certain exemptions on homestead, and it also talks about capping water and sewer rates. So those are the three things that Prop 1 does, and it's focused on the front end of the cycle, assessment and collection. Differently, though, is Prop 2. Prop 2 is not focused on the front end. It's focused on the back end. It's on expenditures. It has nothing to do with how much the city can assess or collect. It has to do with how much the city can spend without voter approval. And if it gets voter approval, it can spend all that it wants. And so our position is that if you...
So doesn't that, Mr. Taylor, amount to an increase in city revenue?
It's not an increase in city revenue, it's a spending issue. So what Prop 2 is saying, you can raise as much as you want, but you can't spend it without voter approval. And that's the difference. And that's why it's not relating to revenue, it's relating to expenditure. But Your Honor, even if you disagree and you say, we think the poison pill is part of Prop 1, we think it was triggered, we still win. Because then you have to reach the question of whether this proposition's poison pill language is enforceable. And that's where it falls apart for sure. Because 9005 of the local government code says that the way you amend your charter is by an up or down vote. It doesn't depend upon whether you get more votes than the other one that's on the charter election at the time. So whichever ones, one or two, get more than 50%, they're adopted. And so the Texas constitutional provision then kicks in. That's section 11, section 5, article 11, section 5, that says when you have something that is violating a state statute or the Texas Constitution, it falls away. And so that third argument, Your Honor, even if you don't agree with the first two, means Prop 2 survives. Now I want to quickly shift gears to the second issue, and that is this. Is there a consistency or inconsistency between Props 1 and 2? And why does that matter? Because if the poison pill language falls apart, survive the consistency part of the argument, because in the Houston City Charter, which is Article 9, Section 19, it just says if you have two propositions passed at the same election and they are inconsistent, then the one with the most votes wins and the one with the less votes goes away. This record is very clear that these two propositions are not irreconcilably inconsistent, and that's what the trial court so found. The reason why
do you contend that Article 9, Section 19 violates Section 9.005 because the inconsistency provision is operating in such a way that it basically renders an ordinance unenforceable, perhaps in part if there's an inconsistency, even though it may have received more than 50% of the vote?
We do make that argument, Your Honor, but you don't necessarily have to get there.
Well, but how can that ever work? I mean, if you, yes, it's true. If both ordinances receive over 50% of the vote, then, you know, I understand your argument about they have to go into effect under 9.005, but what is a city supposed to do if one ordinance says, you know, all the garbage trucks need to be painted green and the other one says they all need to be painted yellow?
Then
you comply with both.
Right. The city would need to go to court. It reminds me of the Hero
But
case.
what rule would a court apply?
Well, I think the court would have to decide is whether or not there are two charter provisions that either can or cannot be reconciled with one another.
Well, in my hypothetical, you can't paint the garbage trucks. You paint them one color or you paint them the other. You can't reconcile it. But I thought what you were saying is under 9.005, the city has no option to get one of those thrown out. You just have to figure out a way to comply with both.
Well, I am saying that, but I don't think you get that far, Your Honor, in the analysis, because once you find that they are not irreconcilably inconsistent, then I am saying that it falls away, because that section is then causing 9005 not to be applicable, because it's saying that Prop 2 dies simply because there's an inconsistency. The city can't do that through its propositions because state law forbids it. If there's a problem between two propositions, then the courts would have to reconcile that. The city can't do it as its own edict, whether it's an ordinance or whether it's a proposition. It can't just decide that one's good and one's not. It reminds me of the Hero case when this court said, look, if you don't agree with what the city secretary said, then you got to file a lawsuit. You can't just engage in self-help and say it's not valid and make the citizens go to court. That's what happened here. We have over almost 250,000 people who wanted Prop 2 to be valid and enforced. And I also voted for Prop 1. So the citizens want both propositions to be validated and enforced, not just one of them. And what I'm suggesting is that this court, as a constitutional matter, if it has the ability to reconcile the two propositions, then it has a duty to do so that the voters' voices are heard. And we believe.
Assuming and focusing on your third point, which requires us to assume that you lose on your first 2 points. And so how can it be that the statute is violated, 05 is violated, if Prop 1 says city shall paint all of its garbage trucks green unless the voters, unless the charter otherwise provides that they shall be painted yellow? I mean, why can't you give effect to both of those because of the unless clause there? And I understand you argue that the unless clause wasn't there. That's your first point. But if we assume it was there, and if it had just very clearly, Prop 1 said, the charter shall be amended to require the city to paint all of its garbage trucks green unless the charter otherwise requires them to be yellow. Why isn't that the circumstance here? And why wouldn't that resolve the conflict by its own language and therefore avoid the statutory concern?
I think in your hypothetical, it could, but I would say it this way. First of all, the Texas Constitution's the top, then the state statutes the next, then the city charter is third, and then the municipal ordinance is fourth in the hierarchy of things. And so what I'm saying is that if the poison pill provision is at that fourth rung, it's just a municipal ordinance, then it can't dictate whether something in the city charter is valid.
Sure, but that's your first point.
It
That's
is.
your first point.
And
but,
then I'm
assume you lose on the first point. I'm having a hard time with your third point.
Understood. What I'm saying on the third point is that the poison pill provision, if it's part of the charter and if it's been triggered, undermines and is in conflict with 9005, because 9005 only requires an up. Let me give this folksy example. Let's say that two of the justices listening right now are both nominated to be the U.S. Supreme Court, and the Senate is going to vote up or down on the two. It wouldn't that because one nominee got more votes than the other nominee, that the first nominee is on the high court and the second one isn't. That's not the way this works under 9005 because they both got 50% or more up or down. And you can't make one of the propositions undermine 9005A and B and undermine the Texas Constitution simply because you want to.
But
Because
they can't both go on the court if there's only one vacancy.
well, in my hypothetical, there's two vacancies. Two vacancies. That's my point. There were
No.
two propositions.
Let
Think
me
about
ask you something else. Should we be concerned at all if the vote was taken with the public understanding that the propositions were sort of competing against each other, and one needed more votes than the other? I know you probably disagree that that's what was in the public's understanding, but if it was, should we be concerned about the judicial imposition of both propositions when people voted under a different understanding of what their votes meant?
I think the answer to your question is, what did they vote on? We know with certainty in this record what they voted on. It's the Prop 1 in quotes, it's the Prop 2 in quotes. That's what got passed. Just like if you're looking at two different statutes from the Texas legislature, you read what they actually passed. Doesn't matter what people said on the House floor or what they thought or what the newspaper said. What matters is what was actually passed. And if you look at what was actually passed, they're not inconsistent and they're not such that one goes and two falls apart.
Any other questions? Thank you, Ms. Taylor. Mr. Taylor, we'll hear from you, Ms. Petty.
Thank you, Mr. Chief Justice, and may it please the court. Make no mistake, what the court faces today is a choice between affirming the Court of Appeals and enforcing Proposition 1 alone, or taking upon itself the task of cobbling together two conflicting single unified plans to create a third contradictory hybrid revenue cap for which no Houstonian ever voted. Now, despite what you've just heard, those are the only two choices. So what I want to do—
So, excuse me, what is your argument in response to his first argument that the poison pill provision, because of just the order of things, it's just not going to work? It's just not something we should even look at.
None of that reflects Texas law. I've attached some demonstrative exhibits for the court, and I would turn to the Exhibit 2, which outlines the election process. What he's talking about isn't anywhere in Chapter 9 or what it takes to get something enacted. And what the city of Houston did was follow Chapter 9, which is what it was required to do. First, council has full authority, just as citizens can put items on the ballot through a petitioning process. City council can put something on the ballot as a charter amendment. That's what it did in Proposition 1. In order to do that, it has to do an election ordinance, which it did. We've attached that as 2A. The election ordinance is 887, I think, 2004-887, and it includes in full Proposition 1, including the primacy clause. Now, Mr. Taylor just makes up law and has for years and years that somehow whether something is in quotation marks or outside quotation marks affects its enforceability. It does not. We attach to our brief two conventions from the U.S. House of Representatives and the Texas House of Representatives that say the only thing that quotation marks affect, everything's valid part of the law, but the only thing that they affect is what actually goes into the law books. And in this case, this directive as to how it was enforced didn't need to be in the law books. And so it was—
Ms. Petty, would you clarify for me, the primacy clause was in the election ordinance,
It's in
correct?
the election ordinance, yes.
Was it also in the adoption ordinance? Mr. Taylor says it was not in the adoption ordinance, and I want to make sure I'm clear on that.
Well, he's pulling a fast one on this because he wants to conflate the canvassing ordinance, which just said, here's how many votes things got, and the adoption ordinance, which is 2005-568. And we know that it's the adoption ordinance because it's the one that was required by the Court of Appeals in mandamus that said that Houston had to include both Propositions 1 and Propositions 2, despite the primacy clause. And so he wants to use another.
Are you saying the primacy clause was in the election ordinance and it was in the adoption ordinance, but was not in the canvassing ordinance? Is that
right? Right. And the canvassing ordinance, and you don't even really need one, as the footnote in our exhibit two indicates. It's just when they become publicly available.
Then my question would be, so when, if ever, did the voters see the adoption ordinance or the election ordinance to know that that language was part of what they were voting for?
The publication requirements, the notice requirements, don't include instructional language like this. And so it was not included in the 5-point type that is sandwiched between the obituaries and the car ads in the newspaper. However, as we demonstrated in the record here, and we got really no contrary evidence. In fact, Mr. Hotze himself agrees that these were presented as separate items. But there were at least 13 articles in the front part of the paper that people would actually read that indicated that these were separate. In addition, in both the election ordinance and the adoption ordinance, even more so, the two provisions were referred to as single unified plans, alternatives, and I think at one point mutually exclusive. So it was there was no effort made to say somehow you're going to get both of these.
But what I'm getting at is, how would a voter have seen the adoption ordinance or the election ordinance before they went to vote on these two measures?
Well, number one, they could get a copy of them because it's a public record. Number two, just as voters get information about election from a variety of sources, the fact that these were publicized, that these were separate items, was publicized in the paper. But let me say something.
You have a statutory obligation to publish it in the paper, right?
We do, but
isn't a voter entitled to rely on what's published there as to what they're voting for, rather than having to say, well, they may not be telling me everything they were supposed to, so I better go get a copy of the ordinance?
Your Honor, there's not a single shred of evidence in this record that any voter mistook the fact that these would be operated together. But let me respond to the real point that you're making. Mr. Hotze has attempted to make claims under 9.004 and 9.004, I think, D and E, about publication and about all sorts of things. All of those, if he had those objections, should have been raised in a timely election contest. In 9.004D claims, for example, or in the
he's not contesting that it was passed. He's just contesting how it relates to the other ordinance.
Well, but what I'm saying is,
everybody agrees that both were passed. So what would there be to contest?
Well, what there would be to contest is the fact that it was in there and that there was not that we were not going to enforce Proposition 2. Which he went to court on mandamus to get included in the adoption ordinance.
Right.
So he was well aware that we were not
contesting that for a long time.
Well, he's been contesting that. As a matter of fact, you were involved in one of those cases, I think, 6 years ago. But the point is that if he had a problem, which he apparently does now, with the fact that this wasn't publicized or whatever, that was the time to raise it. And because he did not raise it in an election contest, the election results, including Proposition 1 in the adoption ordinance, are considered valid and
do you think the election code provides for a declaration of partial invalidity in an election contest?
excuse me, you repeat the question.
Sure. Does the election code provide for a declaration of partial invalidity in an election contest?
I don't, that's
Well,
not really, that's not
What
part
you're
of the elec-
saying is that Mr. Hotze had to file an election contest to declare the primacy clause invalid. So what I'm asking you is,
No,
does
no,
the
Your Honor.
election code allow for that?
No, Your Honor, that's not what I'm suggesting. Number one, it wouldn't be part of the election code. The invalidity would be a part of our charter. But number two, what he would have to do is say that the election, there was something wrong with the ballot language, and therefore the election was invalid. That it wasn't
But
approved the election.
That's not what he's saying. He's saying that he's not contesting that the quoted language of Proposition 1 is valid. And I take it he agrees with the enforcement of Proposition 1 as far as it goes. He just wants you to enforce Proposition 2 also.
Correct, but I think his claims are that now Proposition 2 should have been implemented because of these election process problems with Proposition 1. And our position is that if he had election process problems with Proposition 1, that he should have raised those in a timely election contest. He cannot collaterally attack it now and say, well, it isn't valid, it doesn't invalidate Proposition 2 because of all of these problems. That would undercut completely the election code's timeliness requirement.
His position, though, is that you lack authority to pit the propositions against each other the way you attempted to do because of 9.005.
I understand his position, but his position defies our charter. Our charter gives us the ability to say, you tell us we have to paint a bus green. You tell us that we have.
Let me ask you this: was the additional language added to Proposition 1 about which one gets more votes? Was the city, in your view, using its charter provision to as the authority for that?
Absolutely. What it was essentially doing, and I think it's a pro-democratic piece, was essentially getting buy-in from the voters. They could.
Okay, so let me ask you this then: what if we find that the propositions do not conflict? In which case, the charter provision about conflicting propositions would not have come into play. Would that mean that you lacked authority to add the primacy clause to Proposition 1?
Well, Your Honor, the court is always the ultimate judge of the enforceability of any provision, and that's been established in Colson, in Ray Roof, in a number of cases. In fact, a number in this case, I believe it's the one, the Turner versus Robinson case that Justice Busby was involved in. But I think, in particular, answer to your question, the issue is always grounded in our charter. So if the court doesn't find a conflict, then it would simply disagree with the conclusion that City Council reached. I don't think, however, that they can reach that conclusion because the provisions of Prop 1 and Prop 2 are diametrically opposed.
The trial court found that the two provisions were not in conflict. And what specific ways do the two provisions conflict such that there's an infirmity with the trial court's reasoning?
The trial court did not explain its reasoning at all, so I'm not sure what it is. But if I can,
but to challenge that reasoning on appeal, what
correct.
Specific conflicts would you like us to look at to find that conclusion was either legally or factually wrong?
I've set those forth particularly in the handout number 5, 5A through 5E, and I can go through those because, for example, one of them deals with authority. The Proposition 1 says that the only limitation on council's authority to collect revenue is for property taxes and water and sewer rates. By contrast, and I think that Mr. Taylor's description of what Prop 2 does is way off base. I would remind the court that not 6 months ago, he was in front of this court talking in the Perez case, talking about how Proposition 2 was a revenue cap because he needed that for a refund for his parties. But the Prop 2 revenue cap caps all non-grant income. Consequently, the non-property tax income that City Council is perfectly free to collect without limitation, and that's the language from the charter provision, without limitation, is capped under Prop 2. There's no way to reconcile that. In 5B, we talk about the conflict in the methodology used. The rate.
Well, so I understand the argument about non-property tax revenue being capped, but is there anything in Proposition 1 that says that there can't be a cap on those revenues?
Yes, it reaffirms that City Council's authority to collect non-property tax revenue, quote, without limitation, end quote. So one grants authority or reaffirms the authority that City Council has based on the charter. The other one takes that authority away. And there is no way for us to decide between those two, except to look back to the charter, to look back to conflict provisions, and use the charter provisions to say we will use Prop 1 because it received more votes. And I would say this: the American law, from the Supremacy Clause of the United States Constitution to the Texas Constitution's home rule provision and conflicts, which Mr. Hotze invokes here, to the city charter. These kinds of primacy clauses are ubiquitous in American law because American law is not precise. It bumps up against each other all the time, and there has to be some way, as Justice Busby and Justice Boyd have said, there has to be some way of resolving those conflicts other than running to court all the time. And so that's what these do. But let me get back to your question on the additional conflicts. There are conflicts in methodology. For example, Proposition 1 says you have to use the lesser of a CPI plus population growth rate, or 4.5%. And that's applied to only property tax revenue. Proposition 2 says it has to be CPI plus population. Well, since 2017,
but without regard to limitations on any particular source of revenue.
Well, that's limited in another part. I'm simply going through them. The limitation on other sources of revenue is in Proposition 2. Proposition 1 only limits property tax revenue. But even if, for example, you tried to resolve them by saying,
but Proposition 2 doesn't put any particular limit on any particular source of revenue. It looks at overall revenues.
No, for example, under Proposition 2, and this is again a problem, you could limit other sources of revenue and not limit property taxes at all. You couldn't reconcile that with Proposition 1 that says that you have to limit property tax revenue. So you'd be kind of in a pickle. And even if you said, all right, we're going to just limit property tax revenue under both the same, you then would still run afoul of Proposition 2 because the others would grow at a higher rate. So, or the combined revenues would grow at a higher rate. So there's no way to do that. I think the court has, Justices Boyd and Busby in particular, and I think you're there as well, are pointing to something that's really critically important. The City Council has to govern. Mr. Hotze does not. He can engage in theoretical discussions about how these things can be enforced together, and he can pretend that these are spending caps. They aren't. These are real decisions that the city controller and the finance director and the mayor have to decide. And in this case, on the methodology, there's not a way to resolve that, particularly in an era of high inflation.
But if we disagree with you that there's a conflict between Proposition 1 and Proposition 2, then we never get to the question of whether Article 9, Section 19 comports with Section 9.005, right?
Well, Yeah, I don't think you do. And I would, again, I would suggest that the primacy clauses are pervasive in American law and absolutely essential to governing. But
And
9.0,
you said that the primacy clause was basically a way of the city council implementing Article 9, Section 19. Is that?
I think it was that's where their power comes from. I think what they were
So
doing in it.
should we read them to have the same scope?
Well, no, because I think that the primacy clause in Proposition 1 applies to one election and applies to one set of propositions that deal with revenue caps.
But in terms of the inconsistency standard, should we read them to be the same?
Well, there is no inconsistency requirement under the primacy clause.
Right.
And,
That's why I'm asking the question, because you said the primacy clause is implementing Article 9, Section 19.
Well, I think that's
which does have an inconsistency standard. And so should we basically read one into the primacy clause if that's the authority that city council is using to pass the primacy clause?
No, but I think no, because I think that what they were saying is in this, that they had made a determination in drafting Proposition 1 that it could not be enforced with Prop 2. And I think that's a statement of their intent and a statement of fact, given the requirements under the 2. So I don't think I would read them.
If that is true, would not Section 19 already achieve what the primacy clause purports to achieve, whether or not the primacy clause is included at all?
It would, but Your Honor, I'd like to go back to the idea that I think the city council was trying to be transparent and trying to be democratic. They could have, after this election was over, said, well, you voted for both of them, but we don't think we can enforce both of them, and so we're not going to enforce one.
Which ends up being a question that the courts can resolve. So that was the question Justice Blacklock asked you a while back.
Correct.
I wasn't sure I understood your answer to it.
I'm not sure exactly what the question was,
If
but
it turns out that the courts conclude that these provisions are not fatally inconsistent, does that mean that there was no authority, or at least the primacy clause ends up being something that is wholly, as a matter of law, to be disregarded?
well, no, because it was included. The authority comes from there, but it was included. It was voted on by the citizenry of Houston. It was included in Proposition 1, validly included in the election process as we set forth in Exhibit 2, and so I don't know that that the fact that there's not a conflict under Article or Section 19 means that you simply don't enforce the primacy clause at all. And I think that's what the trial court said, is that it's also a charter amendment. It's also a part of the charter now, because it's a directive that the voters relied upon in voting on it. And that Black versus Strength case that we cite repeatedly says that it would be a misrepresentation to the voters and a disenfranchisement of voters who voted for one thinking that they were only going to get one, to say, no, what we're going to do is we're going to allow a court to try to cobble these together afterward. I think, again, I don't know. And for some reason, my timer has not appeared up there, so I'm just going to continue to talk. I have no idea how much time I have left.
Your time has expired, but you can finish your thought.
Okay. I think what we've tried to suggest here is that the primacy clause itself was part of Proposition 1. That's an independent basis for excluding Proposition 2. If that fails, then we go to Prop 1. But the authority comes out of the charter and out of, frankly, the inherent problem that any democratic institution is going to have with trying to harmonize laws that absolutely conflict. You can't have a green bus and a yellow bus at the same time.
Any other questions? Thank you, Ms. Petty.
Thank you.
Mr. Taylor, 5 minutes for rebuttal.
May it please the court. I want to start with clarifying something Justice Boyd asked about. It's absolutely true that the poison pill language is in the adoption ordinance. When I was talking early on, I said adoption ordinance, and I corrected myself and said I meant the canvassing ordinance. So I apologize for that, Your Honor. So the canvassing ordinance doesn't have the poison pill language in it, but the adoption ordinance does. Now let's think about the timing. The adoption in May of 2005. The election was in November of 2004. So the relevance of sticking it in the adoption ordinance to what the voters realized they were voting on is not connected. And in fact, this record demonstrates that my good friend, Scott Atlas, who at the time was the lawyer for the city, he wrote that into the adoption ordinance. He just declared that it was part of Proposition 1. That has no moment.
Council,
It's the election ordinance.
Council, Proposition 1, and I'm reading from the city's exhibits. So that apparently it says the city council shall have full authority to assess and collect any and all revenues of the city without limitation, except as to ad valorem taxes and water and sewer rates. Why doesn't that conflict with a general cap on revenues?
It's because what I said before, Proposition 2 has to do with expenditures. Proposition 2 does not dictate what can be raised and what type of thing is being raised. It dictates you can't spend it at the end of the cycle without voter approval if you want to go over a certain level. So those are reconcilable and not
the ordinance. Am I reading from the wrong proposition? Because it says it shall be amended to require voter approval before the city may increase total revenues from all sources.
I'm not sure your question, Your Honor.
Well, you're saying that it's an expenditure ordinance or expenditure proposition, but
Right.
It seems to be a cap on any increase in total revenues from all sources.
The best way to answer that is there's three things that happen. There's an assessment, then there is the collection, and then there is the expenditure. There's three independent things that happen with budgeting. So yesterday was the deadline for owners of real property to pay their property taxes. They got assessed much earlier in the year, the previous year, but then they paid it yesterday. But then whether or not those payments that come in are actually spent depend upon lots of budgetary issues. And Proposition 2 is focused on the expenditure, and it doesn't say anything about the assessment or the collection. And that's the key difference. The other point, Your Honor, I wanted to make quickly before I run out of time.
Will you stop there? Because I mean, I can't. The ballot language of Proposition 2, as quoted in your brief, says voter approval before the city may increase total revenues from all sources. Revenues is collection, not expenditure. So I really need some help understanding how you're getting to Proposition 2 being an expenditure cap when it mentions revenues and it caps revenues.
The thing you just referenced relating to revenues, that was authored by the city. That's not in Proposition 2. Proposition 2 is what's inside the quotes. The city, when it decided to put it on the ballot,
it also talks about revenues over and over again.
It uses the word revenue. That's absolutely the case, but it doesn't dictate what revenues can be raised, and it doesn't dictate what amount they can be raised. What it dictates is how much can be spent without voter approval. And so the expenditure is different than the raising of the revenue. And that's why those peacefully coexist. The other thing I wanted to quickly say is that the newspaper notification requirement, it's not what the Houston Chronicle think about this ordinance or these propositions. It's what's actually in the newspaper notification. And that notification does not quote the poison pill language. So to answer Justice Boyd's question, there's no chance that the voters knew that they were voting to include something with a poison pill because it wasn't on the ballot. The poison pill was a municipal ordinance.
There's a chance they knew that if they read the news articles, but they didn't know it by looking at the official notifications.
Well, I would even argue deeper. The newspaper articles that are in this record, they don't say one word about the poison pill. They talk about consistency. They don't talk about the poison pill. The poison pill doesn't hinge upon consistency. It just says if Prop 1 gets more votes, Prop 2 dies. And that's why we've been fighting for 19 years, because there's an ordinance that the city created. They put in this poison pill provision, and its sole purpose was to thwart the will of the voters who voted that they wanted both propositions to be valid and enforceable. And so we asked the court to reverse and render, except for lawyer fees, all of the issues, because Proposition 2 is both valid and enforceable.
Any other questions? Thank you, Mr. Taylor. The case is submitted, and the court will take a brief recess.